Good afternoon, everyone. This is our March session of our uh, webinar series. Thank you all for joining us. We're going to get started here in just probably about 30 seconds to a minute. I just want to make sure we let everyone kind of um, get into the webinar and situated before we start launching into our session on leases. Got a lot of good information to cover today. And there were lots of great questions that were submitted ahead of time. So we'll definitely be touching on as many of those as we can in the time allotted. There were a lot of them. I'm not certain if we're going to get to all of them or not, but we'll do our best. As always, this session is being recorded and it is going to be available on our website shortly. This All right, so it looks like we are starting to slow down. Perfect. So yeah, we will be applying for a CLE credit as well, but I'll get to that in a second. Okay. So I'm just looking at the participant list and it looks like we have, I think we are ready to get started. So I'll go ahead and get us moving along here. Again, this is the March 2024 webinar session for in our ongoing webinar series on tenant landlord law. Today we'll be covering leases, common questions and issues, and we'll be having our delightful and knowledgeable and very fun homeline supervising attorney, Amaryllis Carrion, or Ama. So what is Homeline? Go through that quick in case this is new for you. Homeline, we are a statewide nonprofit organization that helps tenants in Minnesota with free legal educational advocacy services. We've been around since 1992, and we have advised over 315,000 renters since then. Our primary program is our hotline. We do offer that service in 4 languages, Somali, Spanish, and Hmong, as well as English. And then we also have our email and attorney option if that is preferred method of communication. This is our number. These are the numbers for our language lines as well as our website for if you want to email us. Upcoming webinars. We have some scheduled already. So next month we will be covering manufactured homes. That is something that is a part of tenant landlord law, but it's got its own set of rules as well. So it is something that I think will be very interesting to cover. And then May 15th, we will have impacts of new eviction laws on the courts. We'll be having some folks from various aspects of the judicial branch come and talk to us about how they are seeing the new eviction laws going through their courts. So stay tuned for that. And then just a couple of housekeeping things before we get going here. Like I said, the session is being recorded and it's going to be posted to our website in a couple of days. Maybe sooner than that, depends on how long it takes to get through the cloud and all of that technology stuff. We encourage questions. I mentioned earlier, we had a lot of pre-submitted questions, but if there are questions that come up during the session, please, please, please ask them. We love answering them. They're usually really great questions. And so, but I would beg you, please use the Q&A function that is at the bottom of your Zoom screen. If folks are putting them in the chat, I very well may miss them because I will be trying to do about 60 different things at once. So please put your questions in the Q&A and I will make sure I will see them there. And then finally, 1.5 standard CLE credits are going to be applied for this. We will apply for it after the session has finished, and we will send out an email to the participants with that code once we get it. All right, that is me. I'm going to turn it over now to Ama. Please take it away, and thank you so much for being here today.
All right, so let's talk about leases. Next slide. So what is a lease? This is the first question we need to address. And so it's basically a contract. Not basically, it is a contract. Next slide, please. So what are the elements of a contract? There's an offer, there's consideration, and there's acceptance. Basically, someone says, hey, I have this thing. do you want it? The person says, all right, I like that thing. And so I'm going to take it. And then they say, I'm going to take it. And there's usually an exchange for something. And it can be money, it can be a service, it can be many things. Next slide, please. So again, what is a lease? It's a contract. The property owner agrees to offer exclusive possession of the rental property for a specified period of time. The tenant agrees to the rental property based on a set of terms. And all of this is in exchange for money or services. I do want to point out, when people take services, usually you'll see it in the form of labor. Keep in mind that there might be some other areas of law, mainly labor and employment, workers' comp, that come into play. That's not something we focus on here at Homeline, but I just want to point it out for people landlords who want to go ahead and offer usually like a caretaker position. They will have to look into other areas of the law. Next slide, please. So a lease, again, it's a contract that transfers the use of a property or occupancy of land, space, structures in exchange for money, labor, or a combination of both. In Minnesota, which I clearly misspelled, this temporary use of property means that the parties have entered into a binding rental contract. Another thing is that, and I'll go over it in a little bit, there are different types of contracts, and so not everything needs to be in writing. Next slide, please. So there are two main types of contracts, verbal or written. In Minnesota, there's really no requirement that the contract be in writing. There can be an agreement, and then that would establish a landlord-tenant relationship. So how do you enter into an agreement? Next slide. So I prefer, and this is what I advise to people all the time, is to always put the agreement in writing. It just gives clarity as to the expectations and the agreed upon terms. It's not necessary, but it's just what's best. You'll know what's being offered, for how much, and for how long. Usually people who have verbal agreements tend to have some issues as to what the terms are. And so I'm going to keep emphasizing this. Put things in writing, even if it's just the name, the address, the amount of money to be paid, and the term, the lease term. Or it could be, this is just a month-to-month agreement. Next slide, please. So these are the top 5 terms to include in a lease. We do have a video.
Yep, I'm hoping that I clicked the right button this time and that the sound will also come through. Can you hear it?
Hello, this is Supervising Attorney Amarilis Carrion from Homeline, here to give you a top 5 list of elements to include in any lease agreement. Number 5, make sure you include all mandatory disclosures and provisions as required by law. Number 4, make sure you include any rules and policies you want tenants to follow in your building or rental unit. Think smoking, pets, subletting, early termination procedures, and most importantly, notice requirements. Number 3, you need to include information on any fees. Think parking, late rent, early termination, utilities that the tenant is paying for. Number 2, you need to include the cost of rent. That needs to be black and white, very clear. And also need to include the amount of the security deposit and when it's going to be returned in accordance with the law. Look at 504B, period 177. And perhaps the most important provision you have to include in a lease is what I call the 4 W's. Who, what, where, and when. Who is the landlord and who is the tenant? What and where is being leased. So include the address. And when is it being leased? Make sure that the lease includes the start and end date of it, and if not, that it states that it's clearly a month-to-month lease. If you have any other questions about any other elements about what to include in your lease, feel free to contact us at Homeline at 612-728-5767.
All right. Fabulous. Let me get out of that.
That video
My
is
mouth.
available on our YouTube channel. It's a channel, right?
We don't have it's a yeah, we have links on our website as well. I will post them in the
Or
chat
that.
here.
That was a fantastic trip to Florida where I recorded that video.
Oops. Sorry. There we go. Get it back up again. I apologize, y'all. All right, there we go. There we go.
All right, so the next slide. So before you sign on the dotted line, what do you do? Next slide. So this is for tenants. Always see the unit that you're planning on renting. Don't just see a model unit. There are quite a few buildings that have model units, but the thing is not units are the same or comparable. You know, what might be comparable for a landlord, it's, you know, the amount of bedrooms, similar square footage. But as a tenant, you really want to make sure that you like the light in your unit, that you like the features in the unit, that you like the layout. So don't sign until you see the unit that you're renting. Another thing is verify that the utilities are working. Turn on lights, faucets to make sure that you like the water pressure. Check that the appliances are operational. Open the refrigerator. If it has an ice maker, try it. If it has an air conditioning unit or an HVAC system, make sure you turn on the heat and the AC. Turn on the microwave. I mean, there are a lot of things that come into play when you're renting a unit, and you want to make sure that you're renting what you like. Sorry, and that it's also working. Next slide, please. If you see any deficiencies, any issues with the unit, things that need to be fixed, ask for them to be corrected. And this is a big one for me. Make sure that you check to see if the unit is licensed in those cities where there is a licensing requirement. By law, if they haven't followed through with the licensing process, the landlord can't accept or keep rent until they're in compliance. So make sure that you check on licensing. Sometimes landlords forget. Sometimes there are new landlords that don't know that there's a licensing requirement. I'm not going to say take this as a moment to be confrontational, but you can bring it up to the landlord and just say, hey, you know, the city has a licensing requirement. This is where you need to do it. We can't sign a lease until this has been taken care of. Next slide, please. Now, for landlords, this is a new law, and it's critical. You need to follow Minnesota Statute 504B period 120 regarding prohibited fees. Came into effect January 1st, 2024. And basically, as a landlord, you have to disclose all fees, all non-optional fees in the lease agreement. So you will present that in your advertisement and on the lease as a total sum of the rent plus all non-optional fees. And the combination of both is going to be described as a total monthly payment. And then obviously, if you advertise the unit, the same thing has to take place. You will post the advertisement and will say, this is the rent, these are non-optional fees, this is a total monthly payment that will be billed to you, tenant. And then you have to disclose whether utilities are included or not included in the rent. And this includes the common area utility billing. So say the tenant has to handle gas and water, gas and power, and landlord handles sewage and wastewater. But they also want to have tenants pay for common area utilities. You have to mention that. There are penalties for this if you as a landlord violate this section. There are treble damages, and the court can also award the attorney reasonable attorney fees. So make sure that you're complying with this new law, so you can stay in the clear. So fee disclosure and advertisements. This is an example of what it looks like. Examples of common mandatory fees are the portal fee, administrative fee that's usually annual and divided by the number of months. There's some property management companies that charges for landlords, especially in houses. That's what I've seen it as most common. Amenity fees, the utility fees if they're charged by the landlord, internet and cable if it's included and the tenant can't opt out, the lease processing fee, utilities specifically mentioned in the law. Basically, the landlord must disclose whether utilities are included or not included in the rent. And then common optional fees are the garage parking spot or a parking fee, and pet fees. So these are things that just to pay attention as you, the landlord. And yes, someone mentioned it in the chat. This has to be the information on the rent, and the non-optional fees has to be disclosed in the first page of the lease and in advertising. Next slide, please. For single meter buildings, landlords, you should provide the total utility costs for the building for the most recent year. This is Minnesota Statute 504B, period 215, subdivisions 2 and 2A. Tenant asks for it, you have to provide it. And this is so tenants can see on average what is the cost of utilities so that they can count it in as, with their rent and see if they can actually afford the unit. They need to budget. You don't want to end up having someone who really can't afford the unit and then either an early termination or an eviction is the next, it ends up being the next step. Next slide, please. So the rule against perpetuities, and I did this last year and I'm going to stick to it. This is Rachel's doing. She asked me to include it. So next slide, please. I'm not going to read it though. Can't hear you, Rachel. That's a rule against perpetuities. So basically what it, the gist of it is, can a lease last indefinitely? No. Any lease is not intended, does not enter it into for a limited duration of time. So any lease that's not a term lease is then a month-to-month lease. So it's an indefinite term. But in month-to-month leases, what that means is that the lease ends at the end of the term. And it's basically it's month to month. The term ends at the end of the lease. I mean, at the end of the month, I'm sorry. And it starts at the beginning of the next month, as long as people haven't given proper notice to end the tenancy agreement. And statute 504B period 145 really has restrictions on automatic renewal of leases. So landlords look at it if you want to have a clause in the lease about your term lease automatically renewing for a year or 6 months or however long. Make sure you read the law because there are very specific steps that you must take. And I mean very specific. So I personally, I'm not a fan of those clauses because it's kind of jumping through a lot of hoops. I think it's best if you make an offer for a lease renewal. But you know, there are different flavors for different folks out there. Next slide, please. So what are common lease questions? This is for tenants, can a landlord charge me for repairs? Generally speaking, the answer is no. Landlords are responsible for maintenance of the property to keep it fit for its intended use and purpose. However, if you tenant caused damage to the unit and the landlord can show that it was caused due to your willful, malicious, or irresponsible conduct, the landlord can charge you for that repair. What does that look like? Kitchen catches fire. You didn't intend it to catch fire, but let's say and this happened in a previous building I lived in, you are cooking and decide to walk down the street to buy dog food, and then the kitchen catches fire. That was your irresponsible conduct. If you have installed a bidet and you installed it improperly and it leaks, there's a possibility that you will be responsible for that. If you get into a fit of anger and punch walls, you would be responsible for that. Next slide, please. So how long does a landlord have to make repairs? This is a very common question we get here at HomeLine. And so for non-emergency repairs, you give the landlord a maintenance request, and they have 14 days to handle that repair. Now, for emergencies, they have 24 hours to address them. Now, I'm not going to say if there's like a massive water leak, you obviously contact the landlord immediately as soon as you notice it. And hopefully the landlord will send someone to address the issue. The statutes that really address repairs, rent escrows, which is what would be tied to a 14-day non-emergency repair, and ETRAs, which is what's tied to the 24-hour emergency repair requirement, are 504B 161, 504B 381, and 504B 385. I want both landlords and tenants to review those statutes. It really keeps things clear for everyone. And I do want to point out to landlords, this is not super common, but even if a tenant is late on rent or hasn't been paying rent, that doesn't mean that your responsibility to maintain the property disappears. So you still have to do the repairs. And I know that might involve, especially for small-time landlords, it's a cost and you're not getting any income, but see it as the cost of doing business, of being in this landlording business, as I like to refer to it. Next slide, please. Does the landlord have a right to enter my unit without a 24-hour notice? Not anymore, unless there's an emergency. Effective January 1st, 2024, landlords have to give a 24-hour notice to tenants before they enter the rental unit. And they also need to either offer a specific time of entry or a window of time when they will enter the unit. It has to be between the hours of 8 a.m. and 8 p.m. Obviously, they still need to have a reasonable business purpose to enter. One thing is, a lot of tenants want to be present when the landlord or their agents enter the unit. It's not a requirement that they allow this. I think best practice is to try and negotiate with a tenant if they want to be present. This is just to create a good landlord-tenant relationship. But if you can't come up with an agreement and you have to enter the unit to do repairs or whatever it is that you need to do, then just know that you don't have to have the tenant present for this type of situation where you enter the unit. The statute that applies to this is this new law. It's 504B period 211. Next slide, please. So who is responsible for snow removal and yard work? This is like, I'm not from Minnesota, and when I came here, I was like, my mind was blown by this fact. In Minnesota, landlords are responsible for yard maintenance and snow removal. And this is regardless of what the lease says, except if there's language on the lease, and it would be like the tenant maintenance piece, where the tenant agrees to perform specific repairs or maintenance. The agreement has to be in writing. It has to be very clear, and there has to be adequate consideration. What does that mean? It means that they need to get either a rent discount or payment, and that has to be clearly specified. There are quite a few leases that include this language. They will say something like, tenant will be in charge of snow removal and yard maintenance, and in exchange for this, they will get an X amount of money of rent discount every month. Or it can be tenant will be paid X amount of money every month for snow removal and yard work. Absent that language and that specific agreement between the tenant and the landlord, it is always the landlord's responsibility. Next slide, please. Now let's look at fees, or look at them again. So deposits and fees are a source of dispute. This is why we had changes to the law, or one of the many reasons. Landlords, make sure that you list the fees on the lease and how they will be assessed. If it's not written down, you can't charge them. So think of the application fees, the late rent fees, which can't be more than 8%. And by the way, I included the statutes that apply to this. Pet rent or waste fees. Some landlords also do like some sort of DNA testing of a dog to make sure that pet waste is collected. If you have a fee for that, where if the pet waste is not collected and through DNA testing, they can figure out it was like the certain tenant's dog, that fee needs to be listed. Smoking fees, storage fees, early termination fees. I believe we had a question on this, but yes, landlords can charge early termination fees. It's just that it has to be detailed on the lease. Hold fees and pre-lease deposits. This is when a tenant applies for a rental and the landlord wants to have some money to hold the unit. It's fine, and there are some steps that you can take to turn the fee into sort of a way to address lost opportunity if the tenant changes their mind, but you have to follow the law as to how to do this. And so look at 504B period 175. There's a question here. For snow removal, can the lease state the tenant is responsible but not include a payment? No. The lease has to state, there needs to be adequate consideration. It has to say if tenant agrees to do snow removal and yard work, they will receive X amount of a discount. If you as a landlord have questions about this, I would suggest you talk to your attorney. I also believe that there's the Minnesota standard residential lease might have language on this. Then it says all landlords are required to complete snow removal. What about someone who is renting in an HOA where the tenant is responsible? So if you're renting in an HOA where technically the tenant is responsible, it's not the tenant, it's the owner who would be responsible. And so again, you can talk to the tenant and see if they're willing to do the snow removal and yard work. Otherwise, you landlord have to handle it. And it could be you going to the snow removal and the yard work, or you can rent a company, not rent a company, pay a company to do the snow removal and the artwork. But absent the language that where a tenant agrees to do the work and gets adequate consideration or rent discount or payment, it is your responsibility as a landlord. It is really the cost of doing business. Next slide, please. I mentioned this earlier, but for utilities in common areas, common area utility charges cannot be assessed to tenants with current active term leases if the lease doesn't include this fee. The reason I put this in the slide is because I want to say during COVID, a little bit after COVID, landlords decided to start having tenants pay for common area utilities. It became more prevalent. And they wanted to really add it to leases that were ongoing. You can do that. You can start billing or issuing common area utility charges. That's perfectly fine, but it needs to be included in the current lease and after proper notice on term leases, or I'm sorry, after proper notice on month-to-month leases. So usually 30, 60 days, it depends on what the notice was on the original term lease. And if it was just always a month-to-month lease, it's usually 30 days. The billing cannot include any utility use prior to the start of the new lease term. Again, this was more prevalent during COVID. Landlords decided to make the change and wanted to include, say, they said something like, okay, your lease starts, you renew your lease January 1st, 2024, but I'm going to tack in the cost of common area utilities from 2023. You can't do that. And then you have to adhere to single meter rules and its disclosure requirements. So look at 504B period 215 for this. Next slide, please. Rules and policies. These are a source of dispute, so include them on your lease. The clearer the lease, the better it is. And if it's not there, you will struggle with enforcing this. So what am I talking about? I'm talking about smoking policies, pet restrictions, even though you have to comply with the ADA and Fair Housing Act. The illegal activity language, even though there has been some change in the law on this aspect as to um, what would be considered illegal activity. You can't terminate a lease if someone um, was involved in a criminal situation outside of the building. You can go ahead and terminate the lease after that. And the statute number is escaping me. And that, you know, there are other rules and policies. I always encourage landlords that if they have a handbook or a manual for tenants, you include it as an addendum. And obviously, you need to include language that says that, I mean, if this is how you want to apply it, that anything that the manual or the handbook says that contradicts the original terms of the lease will take precedence. Um, Obviously, you need to speak to your attorney who helped you draft a contract or the lease agreement to make sure that the language is on point. Next slide, please. So I mentioned this earlier too. There's a Minnesota Standard Residential Lease. The reasoning behind this is that sometimes landlords use leases they find online or that they obtain from out of state. And some of the provisions in those leases just don't apply to Minnesota at all. The most common that I've noticed is the bedbug addendums. In Minnesota, landlords still have to follow Statute 504B period 161, where they cannot bill the tenants for example, bedbug treatment, unless they can prove that the tenant caused the infestation due to their willful, malicious, or irresponsible conduct. The burden is on the landlord to prove this, and it's really hard to do it because how are you going to show that a bedbug came into a unit? And then pest control is another one that I've seen on leases. There's some landlords who do pest control every certain amount of months and want to pass on the cost to the tenant. You can't do that. Um, I sort of look at it as like taxes, where yes, we know that as a landlord you have costs. You have to build in these costs with the rent. When you're setting up the rent for your unit, you really need to consider what your operational costs are. And these are operational costs, you know, pest control, possibility of having to treat the the building for bed bugs, etc. These are things that you have to build in to rent so that if you need to use the money, you have where to get it from. Um, but you can't just send the bill to the tenant unless you can prove that they caused the problem due to their willful, malicious, or irresponsible conduct. And that's a pretty high standard. Next slide, please. So where can landlords find this lease? We have it in our website. It's a Minnesota Standard Residential Lease. Anyone can use it. I highly recommend you look at it. It's a good lease. Next slide, please. All right, does anyone have questions? And I know we have questions.
We do. And I also want to point out, I was struggling a little bit to get the link in for the residential lease because it does not look like the MSBA, the State Bar Association, has put out an updated one yet to reflect all of the new laws that went into place. So I was hunting around in the background to see if there's a new one yet. And at least my powers of research have not come across one yet. So if anyone else finds it, you know, and want to share it, that would be lovely. But I was unable to. Okay, so yes, we have several questions.
Let me ask one. I just saw one on the chat. So before we go to the Q&A, it's can the property manager ask you to sign an amendment to your current lease to include the common area utility charge? They can present it. You don't have to sign it. There can be changes to your term lease, but both parties need to agree to them. So if you're in a term lease and they bring up this addendum, it's what it would be. You can say, no, I'm not signing this. You can include this on my lease renewal. And it's perfectly fine. I don't feel pressured as a tenant to sign things you don't want to sign. It goes back to before you sign on the dotted line, know what you're signing and know your rights. And so you can say no.
Perfect. Okay. So thank you to everyone who used the Q&A as well. We'll get to you in just a second. But pre-submitted questions here. And I will go ahead and give you a hot second to get some water, maybe breathe a little bit.
Go
So
ahead. I'm
you
good.
and I can alternate in answering these. So because you've been talking for a while, and thank you very much for all of that. All right, so we've got, let's see. Nichelle is wondering, can a landlord enforce a handbook as an addendum to the lease? So kind of a similar question to what was just asked.
I mean, if it's included in the lease, right? So like you have a long lease and then you'll have an addendum including the tenant handbook or
Yeah, usually what I see is a reference that says, tenant agrees to abide by all the, rules and policies included in the tenant handbook, see addendum B or whatever.
and again, I would include some language saying that um any changes to the lease, any contradictory language between the lease and the handbook, the handbook would take precedence. And this is pretty common with addendums. This is not like a bait and switch or anything like that. It's just as a landlord, you have a right to do this. As a tenant, you need to read everything before you sign it and make sure that you understand it.
Mhm. All right. Amber, who I believe is a service provider, is asking, can landlords charge more than 8% late fees,
No,
specifically in income-based apartments?
no.
No.
It's 8%. The lease needs to state if there are going to be late fees
Mhm.
with the amount charged, and it can't be more than 8%.
Yep. So interesting. The verbal leases, oral leases don't have late fees.
I mean, a tenant can agree to pay it, but yeah, basically, if it's not in writing, you can't bill. It's going to be hard for you as a landlord to collect that money.
Sure. All right. So Anna's got a question. They're a tenant, and they've got a question about if a tenant has a service animal and an ESA, are they required to pay a pet deposit or pet rent?
No, if you have an ESA, look at the Fair Housing Act. They cannot. An ESA is like a prescription, so they can't charge you for a prescription. It's not a pet; it's an animal, and so that prescription cannot be penalized. However, if this animal causes any damage to the unit, the landlord can make deductions from the security deposit when you move out.
All right. Fabulous. Moving along. So in general, so Mary's wondering what kitchen appliances is a landlord required to repair?
Any appliance that the landlord provides, they need to repair. As a matter of fact, if you look at the statute covering emergency tenant remedies actions, emergency repairs, there have been some changes to the law. I'm going to pull it up right now so I can go over the list if I find the statute.
It's 381.
Yeah. So the list currently includes if there's a condemnation order for the unit, a tenant can file an ETRA, and then serious infestation, loss of running water, loss of heat, loss of electricity, loss of sanitary facilities, a non-functioning refrigerator. If the lease includes an air conditioner, a non-functioning air conditioner, if the building includes an elevator, a non-functioning elevator, and other essential services and facilities. So if your unit came with an AC, a refrigerator, a microwave, a stove, an oven, those would be considered essential and the landlord is responsible for repairing them. Now, some landlords want to pass on the cost of like a service warranty or something. They can't do that. And the reason for that is that they own the appliance, it's not the tenant. So it would be a violation of 504B 161. Um, Again, it's the cost of operating the business of being a landlord. So just include this in the rent. If these are things that you as a landlord want to have, like a certain insurance, um, you can include that in the rent. You just can't charge the tenant separately for it.
All right. Um, um, so there's a lot of questions on charging common area fees. So we've
Man,
also got a couple in the Q&A and things like
yeah.
that. So we're going to try and cover these hopefully in one fell swoop. Um, so do common area utility charges, are those something that needs to be included on the first page of that lease as part of the fee disclosure?
So yes, because it's a non-optional fee, right? If you're gonna, well, if it's a fee, what you would say as a landlord is, for utilities, I've seen it most common in addendums, but you can just
Mhm.
have a clause in the regular lease, and it will say tenant is responsible for, these utilities, and there will be a common area utility charge, and then you have to specify by law what the billing process is going to be. So how is it going to be allocated amongst
Mhm.
the units? What I've seen most commonly is a combination, like they come up with a formula that includes square footage of the unit, amount of bedrooms in the unit, and the amount of units that are occupied in the building. So, and that figure, it's what determines the percentage that the tenant will pay for common area utilities.
And
Just someone has in the chat, don't the tenants already pay the common area utility costs because they pay the full budget cost through their rent revenue payments? Um, that's how it used to be, but there's nothing saying now. I mean, I hate calling it this because I don't want to sort of slam on landlords at all. But it's more common now for
Mhm.
landlords to show what the actual cost of living in a unit is. And so you have the rent, you have non-optional fees, you have other costs of living in a building, and those are tacked on separately to the tenant. And it's so that I think it's so that people know what they're paying for, Um, this is what the actual cost of living in this building is. It's not just paying rent. And so it's not illegal to do this separate area, common area utility billing. Before it was hidden in the rent, you paid, I don't know, $1,500 and it included everything. Now, cost of living and cost of operating businesses has gone up. So rent might not change, but there are other things you're going to have to pay. Because otherwise, what landlords can do is just raise the rent and not tell the tenant where the money's
Well,
going to.
I mean, one way or the other, it doesn't, it's all going to landlord, whether the landlord
Yeah,
deals with it in the back end or whether it's the tenant who knows exactly where it's going to. One thing that does need to be disclosed though is if there is a service fee for paying those common area utilities or the single meter utilities, that does need to be disclosed as a non-optional fee
correct.
on that first page and as part of the advertisements.
And the reason for that is that it's usually the landlord not doing the calculation. They hire companies to do these calculations, and I've seen fees from 3 to 5%
Yeah.
that
So
that they
that's
add.
just
So
the utility itself may not have to be, disclose what it, because, there's not a flat fee usually for that every month, but if there is a fee for actually paying, I hate this fee, right? Because you have to pay.
yes,
And that is, I don't like that fee
it's
one
like
little
the
bit.
credit card fees. I
Yeah.
mean, the thing is we're not used to them because we used to not see them, and now they're like in your face, and you're like, what?
Yeah.
And then someone says, "But how does a renter know if they are double paying for the common area utility costs in their rent as an additional fee?" You're not. Um, Rent is rent, and in Minnesota there's no rent control, so it's just rent will be as much as the market will bear. And so the rent will be, say, $1,500, and on top of that, you are responsible for the common area utilities. There's no, there's this idea that you pay rent and it should include everything is just not in accordance with the law anymore. They don't
Okay.
have to hide what the cost of anything is anymore.
I mean, they didn't necessarily before either, but yeah, it's just more common now,
Yeah.
right? All right. So one question Lola is asking about is rent increases. Landlord increased the rent in the last year. Are there any limitations on that?
Um, so no. If you're in a term lease, the landlord can't increase the rent, cannot increase the rent while you're on the term lease. For month-to-month leases, they need to give you proper notice of any increase in rent. It's usually 30 days, but it could be 60. Minnesota does not have rent control. So it's as
Except
much
for
as the market
St. Paul.
will bear. St. Paul does. There's St. Paul is the exception. You're
Mhm.
correct. And if you are on you rent a lot for your mobile home,
Mhm.
there is a cap. They can raise the rent, was it twice or three times a year?
Yeah, we'll
And
cover that next month in
yeah,
our
exactly.
well, I thank you for that plug, our manufactured homes presentation. We'll cover that next month. Stay tuned.
Yeah, manufactured homes, the landlord tenant statute applies, but they also have a separate statute that covers other areas. Um,
Hmm.
and rent increases is one of them. But basically, um, up if you ignore mobile homes, term leases rent can't be raised just nilly-willy. Only when your lease is up for renewal, and for the new lease term, and then month-to-month leases, they need to give you proper notice.
Yep. All right, I'm gonna shuffle us along a little bit so we can get to some more of these questions. So this one is, mm, okay, so we've got lots of questions that kind of cover these fees. Whether, what happens if the fees aren't listed on the first page. Um, so I think so for there's Karen, who's a service provider, there's questions about monthly fees like processing fees and things like that. The utilities, the landlord has to disclose what utilities are the tenant's responsibility and what utilities are the landlord's responsibility. They don't necessarily have to say exactly what those are going to be every month because obviously that's going to vary. But they do need to, if there are fees like a processing fee or maintenance fees, those are things that they do have to disclose. Um, okay. The Annette is wondering, so you talked a little bit about damage and when a landlord can charge for damage or not. Um, but a slightly nuanced part of that is what happens, so say for like carpet, right? The, you know, say it's a white carpet, tenant spills a cup of red Kool-Aid all over it. That's you know, that is going to need to be replaced. Obviously that is not normal wear and tear. That's just that happens. But that carpet was 5 years old. And so it wasn't new when they spilled the red Kool-Aid and needed to get replaced. Does the tenant have to pay for the entire value of the carpet?
No, it's a depreciated value. And another part is it's not really recarpeting the whole house or the whole unit. Um, if we're talking about a spot that's like, I don't know, the size of a cup, um, and landlords usually will have sort of a extra carpet that they can fix that patch that area. Um, if it's just like the living room has been battered, but the bedrooms are fine, The landlord can't charge you to replace the carpet in the whole unit. It would be really the area that's affected.
Perfect. All right.
Also, landlords don't put down white carpet. Please.
That's just a personal plea from
I
Mama.
know. Just please.
Um, so what happens? So a tenant wants to end the lease before the term date. Are they responsible for the remaining rent?
It depends.
That's
Uh,
the most lawyery answer possible.
so you need to look at your lease and see if there's an early termination fee. The leases that do include it, it's around 4 months because it's 2 months as a buyout fee to buy yourself out of the lease, and then you have to give the notice, which is usually 60 days. It's the most common notice requirement in term leases.
It doesn't have to
Um,
be that, but it is
it doesn't have
one
to
we
be that.
see often.
Yeah, it's what we see most often. There are other leases that don't have specific language on early termination. They don't have to have it. Landlords don't have to say, sure, you can buy yourself out of the term lease. In that case, if there's no language like that, then what the law says is the landlord has to make a reasonable effort to rent a unit, release the unit. What?
The landlord has to make a reasonable effort to, I'm sorry, I
Oh yeah.
misheard you.
So basically, if say tenant wants to move out, there's no early termination fee, tenant returns the keys. There needs to be an effort on the landlord's part to release the unit, because otherwise it's just sitting there. But go ahead.
So that is something that we are trying to, that is potentially going to be passing this year at the, I know it was language that was going through the Senate, but I don't actually think that has come to fruition yet, Amma.
Okay.
So,
Well, but this is still sort of how we present it to landlords and tenants is that as a landlord, the tenant returns the keys. You don't want the unit sitting there. And why? Why is that? Because it's a loss, right? So you make an effort to rent a unit. That doesn't mean that the tenant is not responsible for rent for the time period where the unit was vacant. They are. As a tenant, you will be responsible until the unit is re-rented. What happens is once the unit is released, the landlord can't charge you after that because that would be double dipping. So tenant, you need to move out. Your lease doesn't have an early termination clause. You talk to your landlord, you try and negotiate. Landlord says, no, you still have to move out for whatever reason. Um, you return the keys, you will be responsible for rent. Landlords will sometimes just send it to collections. Um, it's fine, it's a debt. You will be responsible for it. There are ways to get the amount lowered. To landlords, I say, if this is a situation you're dealing with, you have a lease, it's a contract. You can charge the tenant. However, you want to make money on a unit. The easiest way to make money on a unit is to put forth the effort to to rent it again, so it doesn't sit on the market and you can continue getting revenue. There's always a security deposit, which obviously if the tenant moves out um, early, um, could be used to pay some of the rent that is owed. It first needs to go to any damage that's beyond normal wear and tear, and then if there's a debt, it can be used for that. Tenants, please don't assume that you can move out and you not pay your last month's rent because that's what the security deposit is for. It's not. It's really for damage that is beyond normal wear and tear. It's just that if there's a debt after that, then it can be used to
yeah.
cover that debt.
Yeah, there's really only a few times that a tenant can unilaterally break a lease without getting some sort of mutual lease termination agreement with the landlord. And they're pretty dire circumstances, honestly. It's if um, the tenant is a victim of violence, if the tenant is going up for active duty, if the tenant dies, or if the tenant has a medical infirmity that requires them to move out of the home. Those are the only reasons that a tenant
Move
can,
out of the home for a higher level of care.
yes.
It's very specific. That's actually that's an addition to the law, effective January 1st, 2024.
Yep. I can there that one's a complicated one, but it's essentially
Yeah, it's
all of those are
basically
complicated, right?
they
So,
all are. I think out of all of them, the easiest one is when you're in the military and receive transfer orders. And that applies nationwide. This is not just a Minnesota thing.
mhm,
And this just because it's relatively common for it to happen.
yeah.
Um,
So this kind of goes nicely into Roseanne's question about, can you break a lease for habitability issues? And I can cover this one while you're drinking. All right. So that is another complicated one, Roseanne, mostly because so there is a concept of basically uh why am I blanking on the term? But basically, if the place is essentially unlivable, then there is the idea that a tenant is no longer obligated to, pay the rent and live there because the landlord is not able to provide the place, the place that's fit for its intended purpose. Obviously, the kind of most obvious situation is, say the building burns down, then yeah, that's the constructive eviction is the legal concept. And basically what that means is that the tenant can't live there, and so they no longer have any obligation to the landlord for that space. Unfortunately, there is no definition though of what makes something uninhabitable. And so it is then a sliding scale of, when is something considered uninhabitable. And so a tenant who unilaterally just decides to move out because they've decided that the place is uninhabitable um, does run the risk of a landlord trying to come after them for rent if the landlord does not agree that the place was uninhabitable. And so, it is always, again, best advice we can give is that if a tenant needs to move out early for whatever reason, and it's not one of those, you know, reasons we listed, then it's best if you can just communicate something with your landlord, try work out some sort of mutual lease termination agreement, which is essentially another kind of contract, but ends your lease early. I also want to point out that a landlord cannot force a tenant to stay. Like they can't lock you in your room and force you to be there. So if you need to move, you can move. It's just there are risks to that. Um, let's see. Here, Sarah's a service provider. Can a landlord require or charge tenants for liability for landlord insurance?
um, I think I've seen this more common. It's been more common lately. I don't have a great answer for this one, Rachel.
I mean, so yeah, some of this is getting into insurance law, which is not our area of expertise, but if it's a non-optional fee that the tenant is paying for, whether it's their own insurance, you know, or or excuse me, if they're paying for their own renter's insurance through the landlord, which some landlords are doing nowadays, or any other fee, then it's something that they certainly need to disclose. Um, whether the landlord can make a tenant take out insurance on other people's property, that's outside of my area of expertise as to whether that is legal or not.
I mean, I feel like I've seen some landlords asking to have the tenant list them specifically on their renter insurance policy, and landlords can require tenants um, to have renters insurance. They can
Hmm.
offer one themselves, or they can, or have the tenant provide evidence that they have it through some other company. Um, but I have seen some changes to that, and also like setting a minimum requirement for what the insurance will cover. That's allowed. I think if the question is, can the landlord, if the landlord has their own, policy for the building and they want the tenant to pay for that, yeah, I don't have an answer for it. I think that's something I would have to run by our supervising attorney, because I'm pretty sure in his vast experience, he will know the answer to that. So if you can you shoot us an email? Oh, we have your question. So
Yeah,
we'll
we
ask
can
our supervising attorney to see
we
if
can
he
ask
has a good
around the
answer. Yeah, we'll
we
ask
have a
the
lot of
office.
we have a lot of experience around the office. All right. We are now at 2:30, so we got about 30 minutes left. I'm going to switch over to the Q&A questions that have come through. So this is from Christine. They're wondering what happens if a tenant signs a lease, then finds out that the landlord does not have a rental license? Is the tenant's housing at risk?
Well, the housing isn't at risk. What happens is the landlord can't collect rent. So what I would say to the tenant is tell the landlord the city requires you to have a rental license. Go get that fixed.
Mhm.
And then don't spend that money. Put in a savings account, hold it, because um, you might have to pay some of it at some point. The court isn't thrilled about just letting people live in a property and not pay rent.
Sure.
What you can do is you notify the landlord, through some version of a maintenance request. Within 14 days, the issue isn't fixed, and file a rent escrow. You will pay the rent to the court and have the court decide. That's the safest way to do it.
Mhm. Yeah, there's different cities have different requirements for rental licensures, and what happens if a person is renting a property without a license. That can vary from city to city. So, also, it's good to, as Amma said, check your local ordinances and see what the requirements are. Um, Again, not every city requires a rental license. So, um, and I know some cities have it where the city may condemn the place if the landlord doesn't have the rental license for some time. Like like I said, it varies. So, um, if you haven't moved in yet, might be worthwhile not to put your housing at um through that if you don't have to. All right. So the question again from Christine. So there's 150, so let's say there's a non-refundable admin fee charged along with a $50 background screening fee before anyone's even been approved for the unit. Are those allowed?
If it's disclosed, yeah, I mean, there can be a $150 non-refundable administrative fee and then a $50 background
Mhm.
screening fee. There's nothing that says it can't be done. It's just it has to be clear and disclosed. What we tend to see is not that. What we'll see is um, the fee for the application, and then there's a hold fee. Um, and then that hold fee, um, if the tenant decides that they don't want to rent a unit, if the language is proper in accordance with the law, um, and I will give you the statute right now. If it follows the law, then it's a pre-lease deposit, 504B period 175. There's language that the landlord has to include in that application to say when they get to keep the fee and when the tenant gets it back. If the language is correct, then yes, the tenant could forfeit that hold fee.
All right. Okay, so questions about lots of questions about lawn care and snow removal, of course, as always. This is a big one. So Naomi's wondering, does that apply to single family dwellings?
It applies
The
to
answer is
everything.
yep. It's so 504B.161 is the one we've been talking about, where this you know, tenant maintenance option. And it's a non-waivable um covenant, basically. So, you can't waive it by lease, you can't waive it by agreement. It has to be the only way to have the tenant be responsible for those sorts of things is to have that conspicuous writing that Amma was talking about. So, um, Anonymous is wondering, excuse me, can supplying materials for lawn snow removal be enough compensation?
No.
Probably not. Yeah.
It's a it's a no. You know, if you want the tenant to do the snow removal, adequate compensation really means a rent discount or payment. If you provide me the shovel, that's just great.
I mean,
I still have, I mean, the tenant can agree to it, right? The tenant can say, yes, I'm cool with having the shovel as compensation for the snow removal. Um,
but it is if it's considered adequate or not, that's going to be a question of law. And
yeah, it's
ultimately,
going
if
to
it
be a question
becomes
of law.
or
And
it's, yeah, it's going to be up to a judge.
exactly. It's I would be surprised if a judge said, yeah, it's adequate compensation. A judge can, but you never know. I think I would like landlords to sort of step away from this idea that it's not their responsibility. It's your property. You're renting it. You can include the cost of hiring someone to do the snow removal and the yard work built in into the rent. It is a cost. I understand it is a cost. Or you can just give a rent discount to the tenant. Um, those are the sort of the fair approaches to this.
All right. Shilamar is asking if a tenant is late on rent for say 2 months in a row, um, can the landlord essentially double up on their late fees? So what the statute says, and again, this is 504B.177, is that in no case may the late fee exceed 8% of the overdue rent payment. So it's supposed to be that the landlord is charging 8% per month of late rent.
Okay, hold on a second. Oh, you answered that one. Okay.
Yep. So moving on, unless you have anything you wanted to add to
No.
that statement. Jerry is asking, what are the advantages or disadvantages of a month-to-month lease?
I mean, I think the advantages are if you're looking to buy a property, it really gives you sort of an out from being on a lease, right? It's just that the out will also apply to the landlord because the same amount of notice you have to give if you don't want to renew your lease, it's the same amount of notice the landlord has to give you. Um, so it also like doesn't allow you to keep a better grasp on what the cost of renting is. Because rent can be increased as long as there's reasonable notice. One thing that has become more common in leases, especially corporate leases, is if you want to go month to month, there is a month to month fee. And I've seen them $400, $500 extra a month on top of the regular rent. So in some cases, month to month leases can be expensive. But if you are not sure if you're going to stay living in Minnesota, if you like if you're gonna planning on buying property, if you like the idea of being able to move out of a property faster, then yeah, a month-to-month lease makes sense.
Yeah, and they offer flexibility.
It offers flexibility. That's exactly what it is.
Yeah.
Term leases just kind of lock in a rent, and so you know for a specific period of time how much it will cost you to live in X or Y place.
All right. All right, let's keep moving on. So kind of jumping off of the appliance question from earlier. So say a previous tenant left a microwave in a unit and the landlord doesn't remove it before the new tenant moves in. Is the landlord now responsible for maintaining that microwave?
Well, I mean, if you left it and rented the unit with the microwave, showed it with the microwave, it was stated that it was going to be included, then yeah, it becomes an appliance you have to maintain. Um, Otherwise, a tenant leaves it, consider it abandoned property and chuck it, sell it. if that's not something you want to deal with.
All right. Jerry again wants to know if landlords can increase monthly rent over 20% when a tenant wants to renew a lease.
If you're outside of
Yeah.
the city of Minneapolis, yes,
I
Minnesota
mean,
does
St.
not
Paul.
have rent control. Sorry, St. Paul. Jesus. Um,
Yeah. So yeah,
um,
technically it's
they
whatever
can.
whatever you said earlier, it's whatever the market can bear. So
I mean, that's pretty steep increase, but you know, I've seen worse
we've
things.
seen
I've
them.
seen 100% rent increase.
Yep, it's yeah, it's rough. All right.
I mean, I think on average, rents tend to increase at 3 to 5%. There was a period during COVID where there was a market adjustment, because they couldn't raise rents during the pandemic. But
Well,
yeah,
more than a
20%
certain
is pretty
amount.
rough. Yeah, more than a certain amount.
Yeah.
20% is pretty rough.
Anonymous has asked a question about lease renewals. I am trying to parse it, and I don't know if I quite
Yeah.
understand what the question is. So I'm going to move to the next one and hopefully we can come back to that. All right, so paying rent. Can a landlord require a tenant to only pay rent by a certain method?
Yes, Minnesota does not um, require the landlord to offer multiple forms of payment. So if the tenant has to pay through an online portal and there's a fee, obviously they have to disclose the fact that there's going to be a fee for you to pay. And then, you know, there'll be a credit card fee, whatever. Those fees need to be uh, clearly mentioned. But landlords don't have to accept money orders or checks or cash. And I know this usually tends to pop up when a tenant has been late on rent and the landlord then decides that they only want certified cashier's checks or money orders. They can do that.
All right. Um, someone is commenting about carpet replacement. As is they're saying that judges routinely see carpet as the landlord's sole responsibility. Um, so again, it's that's the judge making that determination. We've definitely seen it go the other way as well.
Yeah.
So, it's I won't say it's the Wild West out there, but it's definitely up to the discretion of whomever you are in front of.
Well, and there's the determination of what normal wear and tear is sort
Mhm.
of, it can be a lot of things to different people. And if you're trying to argue that the tenant destroyed it, you would have to show the evidence for that. So we've seen it go both ways, to be honest.
All right, so
I think this is based, there's nothing in this about compensation for tenants, snow
oh
or
yeah, this
lawn.
is the 504B.161. So very specifically, it says that the landlord is responsible for keeping the place reasonably maintained.
It will
So
not specifically say landlord's responsible for snow removal and lawn care. What happens is it's part of the responsibilities of the landlord. It's maintaining the property.
the curtilage is part of the property. So,
Correct.
all right. Okay. So,
So there's no law, there's case law on the matter.
mhm, yes. Um,
And
so
the
then,
law, the statute that applies is 504B161. Sorry, I keep
it's
cutting you
okay.
off.
All right. So then the if the so going back again to when a landlord can charge a tenant for, you know, repairs and maintenance. Can you just go over that again?
Sure. So sorry. A landlord can charge for damage to the property if they can show that the tenant caused the damage either willful, malicious, or irresponsible conduct. Um, so I mean that's pretty much it. Um, if there is a clog in the toilet and you landlord have to send someone to unclog it, I would hope you would call a plumber. Um, and the plumber finds a buildup of toilet paper and some random truck at the bottom end of the line. Um, you still have to prove um, that it was the tenant's kid who shoved that toilet down there. And so I can't tell you how the court will make a decision on this, right? Because you send the bill to the tenant and the tenant decides to sue because they're being sent this bill, and they don't think that they're responsible for it. You need to have the evidence. Like things I would look at is like what came out first, the toilet paper or the truck? How long was the clog? There are just a lot of considerations the court will look at. But basically, it's the standard is willful, malicious, or irresponsible conduct of the tenant is what allows you to bill them for repairs. There's a question here that I think kind of is similar to this, and similar in vein, which is on shoveling requirements on income-based units. As a landlord, so fine, you can't add the cost to the rent because if it's an income-based unit. You can include it in the lease as long as the tenant agrees to it and you offer adequate consideration. What that means is that you would need to either pay the tenant to do it or offer a rent discount. Those are the most common ways to do it.
Yep. All right. So then the so I think I've got for the first one, the anonymous one. So tenant has indicated that they want to renew the lease, but landlord does not want to renew the lease for another year because they only want month-to-month leases. But they're not, so they're forcing a tenant into a month-to-month. It sounds like the question is that something that the landlord can do? Yes. The landlord does
Landlords get
not.
to, yeah,
Mhm.
they get to decide what type of lease they're going to offer.
Yep.
You should look at, as a tenant, you should look at your lease. Landlords who want to switch from term lease to month for people who are staying in the property after the term lease has ended, they will state it on the lease. It will say something like, if the tenant doesn't give notice or the landlord doesn't give notice of lease non-renewal, the lease will automatically renew into a month-to-month lease, and that's fine. They will also usually include a clause that says if they don't want it to continue on a 60-day notice, they want it to move into a 30-day notice, it will state it there. If it doesn't state it, then it will still be the original notice requirement from the term lease. I know this is very complicated because it's sort of, when you look at a lease as a tenant, it feels like there are bits and pieces that stay and bits and pieces that go. And it is true. And so what you can do if you have very specific questions about your lease is contact us at HomeLine. I would say send us an email through our email and attorney feature and attach that lease so that we can look at it and tell you what's what.
Yep. That is the same thing, Christine, for being charged for repairs. That was what we were just talking about. All right. So then the question of so here's a good one. Carrie's asking, what is meant by reasonably maintained? There is no definition of that. And so that is mainly through case law. Like the baseline is the place fit for its intended use? And what is the intended use? You know, someone living there. are things in working as they're intended? That sort of thing is nice baseline, right? But yeah, unfortunately, Carrie, there is not a definition out there. Amma, do you have any additions?
I do not. And we do have on our website some of the cases that apply to how these statutes are interpreted. And of course, I don't have the page open, so I can't point it out to you.
I can grab it. Hold on.
So I would start there. Um, and I believe we have the explanation as to how the cases apply. Um, there you go.
Yeah, so but yeah, the baseline is that the place needs to be fit for its intended use and reasonably maintained. There is case law that says that the landlord gets to decide what, level of maintenance that is to an extent, as long as something is functioning, essentially. All right. Let's see here. All right, done. Oh, I'm sorry, Margie. Apparently I'm breaking up. Can you hear me all right, Amma?
Yeah.
Okay. All right. Well, I'm in the office with as good a connection as I can manage, so I'm sorry, y'all, if I'm breaking up any. Okay, we've got about 8 minutes left according to my clock. I think we might get through these. All right, so this is a good question about, are utilities, if they're utilities that are the tenant's responsibility, considered rent? And that is a complicated question.
It
Amma.
is. Um, so technically, you can only file for eviction for rent owed. The problem is utilities, common area utilities are usually sent as part of rent. So I would say, say you have, I think this is how I've seen it. You get like a heat subsidy or whatever that should be covering whatever utility, common area utility, the landlord's charging. The landlord has to take that subsidy into consideration. But again, if there's an eviction that's being filed against you, the 14-day notice is just that. It's just letting you know that you have this bill and you have to pay it, and otherwise they're going to file for eviction. And then you still have the right to pay what's owed through the eviction process, and you can in fact apply for emergency assistance to cover these types of costs with that 14-day notice. Just take it to organizations that cover or that assist tenants. It can be the YMCA, Lutheran Social Services, Catholic Charities, and emergency assistance in the county. Whether it's legal or not, I have my opinion that it's not, because it's not rent. But my opinion is not the judge's opinion.
Mm-hmm.
So the advice I give to people is, if you can pay it as soon as possible, go ahead and do it, or set up a payment plan with the landlord to prevent an eviction filing.
All right. All right. Thank you. Okay. So I think there was the anonymous with the year lease to a month-to-month lease, tenant being forced into that. I guess maybe what the question is that, does the landlord need to give a tenant a notice that they are going to let it lapse into a 30 or a month-to-month lease? And no, the notice requirements are for if there's going to be any changes to the lease, or if they're not going to renew the lease at all. So basically, if the tenant needs to vacate, it needs to move out, then that's when the notice period comes in. But otherwise, if things just, keep on with no one mentioning any sort of changes or end date or move out dates, then there's no one needs to say, hey, we're just going to continue on our merry way. All right. And then finally, I'm going to talk to Alyssa, who I believe we both remember. has asked if there's any suggestions over for folks who may not have a maybe not citizens who may be afraid to assert their rights or ask questions or anything like that. Is there anything that you can suggest a tenant does in that situation where there might be something that they don't like in their lease, or they're afraid of, or they don't understand what's happening with it? Steps that they can take.
So immigration status is irrelevant when it comes to landlord-tenant law, in the sense that um, you still have your rights as a tenant. Um, Going to court is not going to affect your citizenship petition or your immigration status adjustment, or affect your status in general. Um, if there is a threat from the landlord to call immigration, for example, because you are undocumented, you can file a complaint with the Minnesota Department of Human Rights, and they jump at those situations very quickly. Um, can a landlord call immigration? Sure. Does that mean that I should call it ICE? Does that mean that they are going to intervene? I don't know. It is more unlikely currently than before, because there's just not enough staff. The thing that I will say, and this applies to people who have status, or don't have status, or those who are citizens, is if you have a warrant for your arrest and you have to go to court for a hearing or an eviction, um, there is a possibility that you will be arrested. What we tell tenants is to take care of that warrant. That doesn't mean that you shouldn't enforce your rights. It just means that most warrants are for failing to appear. It's what we see most commonly. And so you just have to go take care of it in the court.
Yeah.
Um, we can tell, if you give us a case number for, usually your eviction is when this is most common. We can tell if there's a warrant for your arrest. We will let you know. And you can go take care of that.
It's not even just like that's on the public record. So
Yeah, it's in the
anyone who
public
looks up
record,
the
but
case can see if there's there. Yeah.
I say we because it's usually we're the ones who point it out to people.
Hmm.
But yeah, if you go to MCRO, you can look up your own case record and see what's going on. If you have some random warrant because you failed to appear, for a case on a traffic violation. I've seen quite a few of those.
Yep. All right. Last question coming in under the wire. When can landlords rent you without a license if the city that they're in doesn't require one? That's, there are lots of cities across the state that don't require any sort of rental license. So,
And getting a
and
rental license just for landlords, I'm going to say it's a pretty straightforward process. If you go to the website for the city where your rental unit is,
mhm,
it really just requires filling out some paperwork, and some cities will have an inspection requirement, but they do it very quickly because they want properties for rent in their cities.
yeah, sometimes
Um,
there's a fee, sometimes there isn't.
yeah,
It,
might be the fees are usually it's what
yeah,
drives everyone crazy. Um,
sure.
but
But
you should
it's,
do it. It's
mhm,
it's it's a fairly painless process.
yeah. And so that's the reason why we can't give yeah, there is no statewide licensure required. There is no statewide, like, here's what a landlord needs to do to fill out. It's based on your city. And so you got to talk to your local ordinances to see what the requirements are, what the limitations are on leases or not, what happens if you don't have a license, that sort of thing. So, all right, we made it. Check. I'm done. Exactly 3 o'clock. Well done. Thank you everyone so much for coming. Again, this will be up on our website shortly, and I hope you all have a wonderful rest of your day. Take
And if
care
you have
now.
any questions, feel free to email us through our email and attorney feature, and we'll gladly answer your questions.
Absolutely. All right, take care now, y'all. Bye-bye now.